Chair Titus, Ranking Member Meadows, and Chair DeFazio, and members of the subcommittee. Thank you for the opportunity to testify today on behalf of the Project on Government Oversight. At the root of it, we're here today because President Donald Trump has not fully divested from his private businesses, and his continued financial relationship with the Trump Organization creates a specific conflict of interest regarding the organization's lease with the GSA. This arrangement possibly implicates the Constitution's foreign and domestic emoluments clauses. It also presents a possible violation of the clause in the lease meant to ensure that government officials do not benefit from a lease of this sort. As we heard this morning, earlier this year, the GSA's Office of Inspector General found serious shortcomings in the agency's process of determining whether the Trump Organization was in compliance with the lease. Early on in the GSA's review, the agency's Office of General Counsel acknowledged that the President-elect's business interests in the Trump Organization might constitute a violation of the emoluments clauses. Such a violation could constitute a breach of the lease. Despite this knowledge, GSA officials did not consider this issue when determining compliance. Instead, GSA's review focused solely on whether Donald Trump's having been elected president constituted a violation of Section 37.19 in the lease. Based on a flawed legal analysis by the Trump Organization and a legal analysis by the agency's general counsel that has not been released to the public, the contracting officer determined there is no violation of this section. For example, in an effort to limit the scope of the section, the Trump Organization attorneys narrowly interpreted the word admitted. However, the definition they put forth plainly states that it could also mean give access to. Under this meaning, the assertion that the president was admitted to the lease before he was elected is unconvincing, as it doesn't address the fact that he can still access benefits from the lease. I know that members of the minority have expressed frustrations that the GSA IG, in its review of the emoluments clauses, didn't definitively answer whether the president's interest in his private businesses constitute a violation of those clauses. But it appears that no one at GSA wants to be responsible for making that decision. When GSA's contracting officer determined that the Trump Organization was in full compliance with the lease, he knew of the existence of this possible violation and ignored it. This decision was made before litigation on the emoluments clauses began. This calls into question the prudence of his decision to issue an unqualified estoppel certificate to the Trump Organization. Even absent undue interference, serious questions remain about GSA's handling of this matter. Given the serious nature of the Inspector General's findings, the agency's response was grossly inadequate. Written by the agency's general counsel, the response ignored all but the Inspector General's one recommendation and placed the blame for the report's primary findings on former agency officials. The tone of the letter was at times jarringly contemptuous, appearing more concerned with protecting the president's reputation than ensuring the agency is operating in full accordance with the law. Ignoring the Inspector General's statement that it would not examine whether the president's interest in the hotel violates the emoluments clauses, the general counsel misstated that the Inspector General does not find any constitutional violation occurred. He further asserted that the Inspector General found an emoluments violation is merely possible, but disputes that claim, pointing to ongoing litigation in which the Justice Department is arguing that the president's business interests do not pose a violation of the emoluments clauses. The general counsel ignored the fact that in those lawsuits, Justice Department attorneys are exercising their role as the president's civil defense attorneys. The Federal Programs Branch of the Civil Division, as described on the department's website, defends civil actions against the Executive Office of the President, such as the emoluments clause lawsuits the general counsel cited in his response. As the Justice Department is zealously arguing for an interpretation of the law most favorable to its client, it's hardly an impartial arbiter of fact or law in this situation. To present the department's assertions as impartial, like the GSA's general counsel did in his response, is misleading. The conflicts of interest apparent in the lease for the old post office building may well be being managed appropriately, but it's inadequate and unfair to ask the public to blindly trust that an agency under the president's authority will manage those conflicts properly. Instead, the Trump Organization and the GSA should cooperate fully with oversight efforts of members of Congress. That oversight extends to examining the IG's review of the agency decision-making process. I'm therefore additionally concerned by a lack of productive response to a request for records from the GSA Inspector General submitted in part by Ranking Member Meadows. In closing, it's important for us to take a step back and consider the broader policy implications of our conversation today. The fundamental issue is whether we as a country are okay with a system that allows elected officials to privately profit off their official actions. If the answer to that question is no, as is suggested by the emoluments clauses in the Constitution, then we need to take a serious accounting of the laws and policies governing the conduct of those elected officials to ensure that they are sufficient. In this committee, that starts with GSA contracts. Thank you very much. I look forward to your questions.